Good afternoon, everyone. My name is Baldev Binder. Welcome to our webinar today on letters of credit. I'm joined with my colleague, Ms. Raman Kaur, and we'll be talking about the dark arts of commodities trading and how it applies and how it affects letters of credit in our current business. I think we'll just wait for a few seconds to let everyone into the group. If you have some housekeeping rules, I suppose, in the meantime. If you have any questions, please feel free to ask at any point of time. I will give a bit of background as to letters of credit and letters of indemnity and all these technical terms that are used by judges and in the courts. And at the same time, I will talk about the most recent case, which was Zenrock and the case of Zenrock and Credit Agricole and PPT. My colleague will talk about Winson oil involving the Hin Leong debacle a few months ago, that came out a few months ago as well. So let's get right into it, right? The agenda for today we'll be talking about some of the background, the basics of trade finance and how that applies to letters of credit, and then we'll jump straight into the cases. So the building blocks. What do we talk about when we talk about LCs, LOIs, BLs, all these fancy acronyms? I'm going to jump straight in and give a bit of an explanation as to all the different things that operate. Now, I've noticed from the audience, most of you guys are within trade finance, within the banking and trading community, so most of this stuff should be familiar to you. But I want to give a bit of a breakdown as to how the documents flow and how the goods might flow a different way. So in any sort of trade structure, you've got three acronyms that I'll be using quite frequently in today's session. We'll be talking about bills of lading, which are BLs. We'll be talking about letters of credit, and we'll be talking about payment LOIs. Now, let me explain the three concepts in as best as I can in layman terms. A bill of lading is essentially what we call a title document. It's a document that gives the owner, generally speaking, gives the holder of the BL, if it's a negotiable BL, a right to get possession of the goods. So, give you a simple concept. If I walk into a shop to buy a can of Coke, I pay for it, I take physically that can of Coke, and I walk out the shop. That's how it works. International trade requires moving goods across water. When you move it across water, there's a carrier, and the carrier, being the shipping company, they issue this bills of lading in return. And that bill of lading gives the holder the right to go to the carrier and say, hey, these goods are mine, and the carrier is meant to deliver it to the holder of the BL. Possession, the same way you take your can of Coke and walk out the shop, possession is the key in international trade, and that's why the BL is also known as a title document. It is the possessive quality of the BL that gives meaning to this word title document. Letters of credit are effectively a payment mechanism whereby a bank pays on behalf of a buyer on presentation of certain documents. What are these documents? Typically, it tends to be an original BL alongside other shipping documents. Payment LOIs. Now, payment LOIs are unique feature and creature of the oil industry. No other commodity, and I say this as a firm that does commodities, no other commodity has the use of payment LOIs have the use of payment LOIs be so prominent as it is in oil. In fact, I haven't seen payment LOIs in any other type of commodity. So a payment LOI, put it simply, is an IOU. It is a promise on a piece of paper that I, as the seller, I've got good title to the goods, and I will give you the original title documents, things like the BL, when the time comes, or when asked for it. That's effectively 2 or 3 promises written down on a piece of paper. How does this operate in international trade? I've put on the diagram before us. You've got a supplier who sells to a seller onto a buyer. Now, the bank in this relationship is the buyer's bank. The buyer goes to the bank, says, Mr. Bank, can you please open an LC on my behalf? That LC is open in favor of the seller. meaning that the seller then presents whatever documents are required under the LC, and it expects to receive payment in return. Now, two fundamental concepts, and if there's everything you take away from today's session, let it be these two concepts. Number one, an LC is an independent, autonomous document, an obligation, meaning that the rights contained within that document is a standalone. There are no other ways of actually, there's no way of looking underneath the LC. There's no way to sort of testing whether the trade really happened or didn't happen, apart from the fraud test. That's number one. An LC works, and international commerce works because an LC works independently. Questions about the quality of the goods, whether it's the right quality, whether there's like quantity, whether there's a rise in the right port, all of that is somewhat irrelevant when it comes to presentation under an LC. That's why it's known as a documentary credit. That's point number one to take away. And the point number two that I want to stress on is that traders increasingly or habitually have been motivated to insert themselves into trade chains of which they don't understand. So I might call Raymond, Ms. Co, and say, I've got a trade flow. Here are the documents. Can you pass it on to my friend, Mr. X? And she then passes the document on. That on paper looks like a trade flow. Raymond might not have any idea whether she's buying oil cargo or whether she's buying a container full of unicorns. No idea. She's never seen the cargo, will never see the cargo, and she's essentially trading on documents. And that's where the problem lies, because you create a world of that could end up being a fiction, a world of documents versus a world of physical flows, and the two might not necessarily coincide. The point of a payment LOI, as I just mentioned quite quickly just now, is to really facilitate the payment under an LC without presenting the original BL. Now, I want to stress how radical this idea is and why it doesn't feature anywhere else in international trade. A payment LOI, a cargo of oil, $20, $30, $40, $50 million, that's one cargo of oil on a tanker. And what you hope before you pay that $40, $50 million, or you get your bank to pay on your behalf, you would hope that you get the original title of documents, that you own this cargo before you pay. Commonsensical, right? But the practice of the oil industry, for historic reasons, which I wouldn't want to get into at this point of time, is that they felt, let's do away with the original BLs because we all kind of know each other and we trust each other. That's the historic background behind it. Today's oil business is very different. You have multiple players involved. But that practice of trust, where you don't need the original BLs, where a person says, I haven't got the original BLs, but here's a piece of paper where I put an IOU for $40, $50 million instead, and that's going to replace the original BL. That mechanism has been going on, I don't know for how long, but it still goes on even today. Even with the trade fraud that's happened in the past few years, the use of payment LOIs still feature very prominently in the oil trade. You shouldn't confuse yourself with discharge LOIs, and that's a separate document that's given to the shipping company to release the goods. Payment LOIs, as the name implies, I think, really is to facilitate the payment under the letter of credit. What does the payment LOI say? I think I've put it on the screen over there. Essentially, it says that person's got good title. The seller will then locate and surrender the shipping documents. And if the title turns out not to be good, then the seller will indemnify the buyer or the addressee of the LOI instead. So that's the background to it. Let me jump straight into the case law and then the cases. So in terms of the law, the only exception to not paying on a BL not paying on a letter of credit is the fraud exception. Fraud exception meaning that only the fraud of the beneficiary can taint a presentation. So it doesn't matter if the applicant, who might have been the orchestrator of the entire flow, it doesn't matter if that person is fraudulent. if the beneficiary is completely innocent, hands are completely clean, then the law requires that the documentary credit performs and the bank has to pay. So the bank doesn't have to pay if the bank can show, and it's the bank's obligation to show fraud on the part of the beneficiary. And the second point being that naturally you don't have to pay if the documents are not compliant under the letter of credit. That's a separate conversation altogether. I'm going to now jump into the Credit Agricole and PPT case. And I spoke about this in March of last year when the decision first came out, because I found that there were certain findings, or the result perhaps wasn't quite justified, I suppose, to put it that way. So I had some criticisms as to some of the findings that were made, and I had that out last year. I'm going to use the same slides that I had from last year. This decision has gone on to appeal, and Credit Agricole has since won the case, meaning that the decision of the first instance court was reversed. Let me explain to you what the decision of the first instance court was, and then we'll go on to the appeal decision. So, starting on the left of the screen, you have a company called TOTSA, that is Total. Total sells to Soka. Soka is a major oil company in Azerbaijan. Then it sells on to Zenrock, Zenrock onto Total. If you focus your eyes on the green boxes, that's the true contract, the actual contract flow between Total, Soka, Zenrock, and onto Total again. Now, Zenrock at that time, this was during the crash of 2020, Zenrock was going through some liquidity issues, from what I imagine, and so it needed to raise liquidity quickly. And one way it thought about doing it is maybe just create another trade flow using the same physical flow, but create another set of documents so you can raise financing a second time. So now if you focus your eyes on the blue box, Zenrock created a fabricated contract involving Total. What's the difference between the true contract and the fabricated contract? One of the key issues that I felt in this case was the pricing. The price of the true contract was at negative Platts. This was March 2020. Oil had crashed. It was on the front page of every newspaper. Oil had just gone down, and so it's at a negative value. Zenrock then fabricated a bunch of contracts and put it at Platts positive. So that's one red flag to sort of speak of in the first place. What else did Zenrock do during this to create a second trade? So the first trade flow, if you once again top half of the screen, Zenrock buys from Soka, sells to Total. It goes to ING, tells ING, I've got a trade flow. I'm buying from Soka, selling to Total. Both my seller and buyer, gold standard clients. ING is happy, box tick, and they get the financing in return. Now, as part of the financing, obviously, ING gets a charge over the goods, and that's quite standard in trade finance. The charge is a key point, so I'll come back to that in a second. In the meantime, Zenrock decides, well, I'm going to create a fabricated flow as well. I'm going to create a fabricated contract, and to do so, I need to create a round-tripping exercise back to myself. So Zenrock then puts together another trade flow involving Shandong, PPT, back to Zenrock again. Now, 2 or 3 points are quite important to bear in mind in this. First, the pricing of oil. Secondly, from what I gather, PPT and Shandong probably didn't know each other. They were just inserted into it. The evidence that appeared in the first instance court seems to suggest that Zenrock was simply telling the parties to insert themselves, and they were willing to insert themselves whether as seller, whether as buyer, it didn't matter. As long as Zenrock said jump, I think it appears to be that the parties were willing to say yes sir, 3 bags full sir. And that is the type of trade flow that I think traders increasingly over time feel with the pressure of the business might feel incentivized to just insert themselves in there, ask no questions, get a margin in return. And that's one of the fundamental learning points over here in this case, because PPT initially was inserted into this trade first as a seller to Zenrock, and then as a buyer from Zenrock. So they were trying to figure out different chains, one involving Trafigura, and they were trying to formulate different ways of putting PPT in. And PPT just said, no problem, whichever way it might be, I'm happy to do it. PPT then, the point to PPT and the point to most traders is quite simply this, is that why ask more questions? Why ask whether this oil really exists? Why ask whether the cargo is of the right quality? Why ask any of these questions? What's in it for the trader? The less you ask, the better from the looks of it. Because the fundamental concern of the trader is, will I be paid my margin? And who's going to pay my margin? A bank with a letter of credit. And that bank with a letter of credit for the longest time, and still I would say is going forward as well, is gold standard. But that doesn't mean that the trader takes his eye completely off, ignores all the red flags that might be before it, and just presents happily under a letter of credit, ignoring what is the stark reality before it. What was the stark reality that PPT ignored in this case? The pricing of oil, number one. The second point, where it was seller one day, the next day it was asked to be buyer for the same cargo. It didn't matter. Didn't really know where it was getting the cargo from. All of that stuff, PPT didn't seem to apparently know. All it cared about was really its margin. I think that was the evidence that was put before the court. So this decision went to a first instance court. Credit Agricole caught wind of the fact that there was possibly some double financing going on, and Credit Agricole refused to pay at that point of time. Subsequently, Credit Agricole paid into an escrow account, and then the case went into litigation. The point that Credit Agricole raised in litigation in the first instance court is this. It said PPT had acted fraudulently. Why? Because pricing was inflated. It was positive instead of negative. It was inflated by 80, 90 times. There was a round tripping going on. Zenrock was selling and buying back to itself. PPT never received the original documents or shipping documents, had no idea which way was left or right, just presenting under an invoice and a payment LOI. The second argument that Credit Agricole raised is that the transactions that PPT was involved in is a sham, simply because it was a financing deal. PPT was not interested in the actual goods themselves, and PPT didn't receive the original title documents. Remember the BL, the original title documents that I spoke about. Third argument was that there was misrepresentations as to title. And the fourth point is that the payment LOI, which is, I would say, for all these years, a bit of a safety catch. Whether it's a good or bad safety catch, that's quite debatable. But it's a bit of a safety catch when it comes to the oil trade, because a bank is paying $20, $30, $40 million, and its only comfort really is the letter of indemnity, because the original BL might not be in motion. So all it relies on is the letter of indemnity, which promises, as I mentioned, two things: good title and a guarantee, a warranty to surrender the original BLs when the time comes. The court found in this case, let's go through one by one, yeah? They sort of said, PPT, yes, PPT knew that there was round tripping going on. They said, I think there was a bit of colorful language somewhat in terms of PPT's knowledge as to the pricing. PPT's position was quite simply that they didn't know that the prices were so inflated. I think there's a question mark as to whether an oil trader could possibly say that credibly, that they do not know or did not know that the pricing of oil is inflated by 20, 30, 40 times, whatever that number was. So the court found, well, PPT, although their conduct might not have been great, they thought they were part of a trade. They presented the documents. They were not dishonest. And so they should get their claim under the letter of credit. In return, The safety catch, which is the LOI, that didn't kick in. And it didn't kick in because, unfortunately, the LOI spoke of language where the LOI was to become effective after payment is made. LOIs, payment LOIs are pretty standard documents. I think for the longest time, it often speaks and opens with the language to say that in consideration of a bank making payment, the seller promises A, B, and C. And because the bank, Credit Agricole, did not make payment in time, it was not entitled to the promises contained within the LOI. That was the unsatisfactory decision at first instance that was left. There is confusion around fraud, although the test for fraud and whether the correct test was applied and all of that stuff. But when you look at it, and I've put before different facets of fraud, I think the law, when it comes to the application of fraud, it's pretty uncontroversial. It comes from the tort of deceit, and if you focus on the right box in brown, there's a three-limb test from the tort of deceit. You either know it's false, or you have no honest belief it's true, and the third limb is that there's a reckless indifference as to whether the things you're saying is true or false. Now, this three-limb test comes from Darien Peak. It's a classic case, classic formulation. No one's really contested it. Even during the classic formulation, the judge sort of said reckless indifference, which is limb number 3, it could possibly fit within not having honest belief. Because if you don't have honest belief in what you're saying, then I think it's fair to say that you're being recklessly indifferent to whether something is true or false. This three-limb test forms the basis of deceit. Deceit is a tort in law, and from there, I think you get different cases talking about different aspects of this three-limb test. So we have a case involving recklessness, and that's the case of Arab Bank in the middle. And in that, it speaks quite squarely of the test of fraud involving recklessness, meaning that, as I read out loud, a reckless indifference to the truth or falsity of what's being asserted at that time constitutes fraud. Now, Arab Bank deals with demand guarantees, which, in my view at least, applies quite similarly, or actually on all fours, as the way as the letter of credit would. That's Arab Bank in the middle, and then you've got Brody and White, which talks about knowing that the representation, actual knowledge as to whether something is true or untrue. So if we harness all of these formulations of the law, it is still quite there that you either know something is false when I'm presenting to the bank. I either know this trade A did not happen, I didn't really have good title in it, I've actual knowledge of this. Maybe because it was a bag of unicorns or something, and that's why I can't possibly say that this is true. Or I have no honest belief. And without honest belief, I think you start entering into the realm of beneficiaries confronted with information that contradicts his understanding as to whether he's got title or not, or raises questions. And they choose not to. They choose not to ask a further question. They choose to ignore that. And in my mind, not having honest belief and reckless indifference it's quite analogous. It almost can say that it's one and the same. And that's where I think the court at first instance said reckless indifference. No, we're not counting that in to be part of the fraud test. And I've put up paragraph 21 of the judgment at first instance. And I've bothered to put all these words up on a slide, which I rarely do, but I thought it's quite useful to actually read about it, to read what's being said. Now, there are parts, I'm going to break it down, the different parts of this paragraph. We're talking about dishonesty and whether recklessness constitutes fraud. Now, that is an important point to remember from this seminar. Does recklessness constitute fraud? In this case, in the first three sentences, they say, in the first 3 lines, they say, no, it doesn't, because it doesn't vitiate presentation. Now, you know what we talked about? Absence of belief of something, whether it's true or false. That the judge went on to say that while in absence of belief in the truth of representation, in the sense of not caring whether it's true or false, not caring whether it's true or false, that's reckless. And the first part of the sentence, absence of belief in the truth of representation, that's without an honest belief. So that's why I say it's analogous. The two concepts actually quite fit quite neatly. In this case, the judge is saying, that's fine, it fits for deceit, but it does not apply when it comes to a presentation under a letter of credit. And that is where I think I have my fundamental disagreement with the judge, or in this case over here, with all respect, because I think if it's good enough for deceit, the formulation for fraud, whether you apply it for deceit, should apply equally when it comes to letters of credit as well. Meaning that if you don't have honest belief, i.e., I would go as far, if you are reckless whether something is right or whether you're reckless whether something is true or not, then that should constitute a ground for fraud. Now, remember I spoke about Arab Bank, and Arab Bank talks about recklessness as fraudulent, right? So the judge then distinguishes Arab Bank and says, Arab Bank has to do with demand guarantees. And so demand guarantees don't apply the same way as letter of credit. I'm going to stick to Brody instead. Nothing in Arab Bank conflicts with Brody. And that's, if we go back to that slide again, I think that's where the disagreement, the difference in opinion lies, I suppose. That Arab Bank talks about recklessness in a demand guarantee situation. Recklessness, it's quite compatible with the idea of not having an honest belief. And if you don't have an honest belief, then are you not fraudulent? So that's what. So on that basis, I think even though I would have disagreed, or I was quite vocal in disagreeing with the judge at that time, that was the decision at first instance. The fraud test not made out because it didn't matter if PPT were reckless. They didn't have actual knowledge as to the fraud. Then the safety catch, the LOI. Okay, if you haven't got through if you can't deny payment on the letter of credit, what happens to the payment what happens to the promises in the LOI? And now I've put up the slide for your consideration. This is the actual language being used at the Credit Agricole case. And it says, in consideration of you making payment of the price of 23 million, you promise the underlying words that property passes under the contract. At the time property passes, seller had good marketable title to such shipment, free of any lien and encumbrance, and all the rights and ability to transfer that title to the buyer. So all these promises only kick in after you make payment because it's in consideration of you making payment. That was the view of the judge, that this was effectively a unilateral contract, and until payment was made by the bank within the requisite time, these promises didn't kick in. I'll stop there for a minute. That's where we were at first instance. So Credit Agricole had lost PPT. They were deemed to require to pay PPT the required amount under the letter of credit. Any recklessness to do with PPT was deemed not to satisfy the fraud test under letters of credit. Then it goes on appeal. And the appeal decision came out, I think, less than a month ago, if I remember right. And what were the issues that went on appeal? The first point is whether Zenrock's fraud was enough to set aside liability under the letter of credit. So not PPT's fraud. PPT's fraud and whether PPT's conduct could be said to be fraudulent. That was not appealed upon by Credit Agricole, which is a bit of a shame. But the question that they went on appeal for is on whether Zenrock's fraud was enough to taint the letter of credit altogether. And then the second issue was about the LOI, because if you don't succeed on the fraud, then the LOI mechanism is your safety catch. It should promise to give you these warranties as to title. The point on the LOI was whether it was effective from the date of issue, i.e., was it the case that the LOI was suspended until payment was made and then the LOI came into existence, sprung into existence, or did the LOI and the promises contained in the LOI existed from the get-go, from the date of issue. If the LOI was effective from the get-go, then these warranties as to title, as to marketable title, was then breached. So these are the three issues that were put before the court. I'll deal with the first issue quite quickly because the first issue was quite simply this. It's effectively saying, in most fraud cases, you would find that the applicant has orchestrated the fraud simply because the bank has taken on the payment obligation on behalf of the applicant then disappears, goes into insolvency, and the bank is left carrying the can. And in that case, where the applicant has been guilty of fraud, can that taint the entire structure altogether? And the answer, I think, correctly and quite unequivocally is no. I think the law is very clear, as I mentioned at the start of the webinar, that it is only the beneficiary's fraud, not the applicant's fraud. It's only the beneficiary's fraud that can help to avoid payment under a letter of credit. So that's issue number one. Issue number two, the effectiveness of the LOI. Now, this was a really important issue because I cannot stress the billions of dollars of oil cargo that are bought and sold and financed off the back of this flimsy one-page document called a payment LOI. And if it wasn't deemed effective until payment was made, then you are always going to end up in a situation that you have to pay as a bank and then seek to claw back the money, which might not be satisfactory in a situation where you're dealing with a questionable beneficiary or a financially insolvent beneficiary. So on the second point, the court decided that bearing in mind the whole underlying arrangement, surely the LOI was meant to come into effect at the start. As soon as it was entered into, the LOI was meant to come into effect. The transaction always contemplated that the LOI was meant to be used because there was no original BLs. And it's not something that you can withdraw. It's not like an option that you give someone and then you can withdraw it later. The LOI, to say that payment was condition precedent towards the effectiveness of the LOI, it was adding a requirement or a complexity to the transaction that wasn't there. If payment was if it was a condition precedent, then it would be in the letter of credit itself. The letter of credit itself would say bank will only, the bank has to pay before it gets the benefit of these promises in the LOI. But there was no language of that nature. So if the LC, which is the main instrument, doesn't talk about condition precedents, why should the LOI be deemed as a condition precedent? Why should payment be deemed as a condition precedent to the LOI payment? I want to get to the interesting part, and that's to do with marketable title. I'm conscious of time as well. Marketable title, quite simply, is this. Remember that the LOI says, I've got good title. That when I'm as a seller, I'm passing good title to the buyer. What does that mean? What does good marketable title mean? And I think it's a legal term or term of art, put it that way. And the description that was put before the court in the Court of Appeal that was that seemed to be uncontroversial is that it's a title that, I suppose to put it quite simply, it's confusing language that I put on the screen, but to put it quite simply, it is title where you are not exposing the buyer to litigation hazard. If you give someone a questionable title, then, or the title can be questioned, then there's a litigation hazard attached to it. That's not good marketable title. And this is where the key feature comes in. Did PPT get good title from Shandong and in return pass good title on to Zenrock? And one of the key issues, remember at the start of the slide, I talked about charges. Zenrock, because it was doing double financing, right? Zenrock had issued one charge to ING and another charge to Credit Agricole. Both the charges were obviously inconsistent because it's over the same goods. And so you can't, once you have charges over the same goods that are inconsistent, that affects the title of the goods, obviously. And I think it's also the case of the goods then being subject, the claim being subject to litigation. So the charges, which I think most people don't quite apply their mind to, was actually quite fundamental in terms of then giving the complexion that this was not title being passed that was free of litigation. The last point on this slide is about PPT not being a bona fide purchaser. And remember all the issues I had with PPT's evidence in terms of them not knowing the price of oil, them not knowing it was inflated, them willing to be sell it today, buy it tomorrow, it didn't matter sort of thing. All of that stuff, not asking the questions as to whether it was really buying oil or whether it was just inserting itself into a merry-go-round without really passing any real title. That was really that part that would have otherwise constituted reckless behavior, was the same sort of factors that also applied towards why it wasn't a bona fide purchaser. How could it be a bona fide purchaser? Because as the court below found, Zenrock knew about the round tripping, it knew that it was just doing financing, and in the brackets, in the italics at the bottom of the paragraph, I think the Court of Appeal also found it remarkable at paragraph 13 and 14. It said, remarkable as PPT's ignorance of even the general level of market prices and its disinterest in what was going on. This is the factual basis on which the appeals proceed. So there's been no attempt to disturb the judge's findings on the PPT's conduct and whether that constitutes recklessness and whether by extension that recklessness means that it's been fraudulent. That had been left open, but that same behavior or elements of that same behavior were deemed to mean that it was not a bona fide purchaser, and because it was not a bona fide purchaser, it was then not giving good marketable title under the LOI. So in a roundabout way, the safety catch of the LOI fortuitously, I have to say, worked in this case. I'm well aware that I've gone over my time. I want to hand over the floor to Ms. Kaur, who's going to speak about Winson Oil. And when I pass over the floor, I want to remember this open issue about recklessness, about whether recklessness constitutes fraud and whether it's part of the fraud test for letters of credit. That was an issue that was addressed head on in the Winson Oil case. So over to you, Ms. Kaur. I think you're mute. You're still on mute.
Thank you, Baldev. Hi, everyone. I'll be covering the case of Winson and OCBC. Here, OCBC and Standard Chartered Bank, they were resisting claims for payments made under LCs by Winson, whilst we saw earlier that Credit Agricole did not succeed at first instance before the SICC in demonstrating that PPT's presentation of documents to obtain payment under the LCs was fraudulent. The banks in this case, in fact, managed to establish Winson's presentation as being fraudulent. So very quickly, the facts are as follows. OCBC and Standard Chartered Bank had issued LCs to pay for gas oil that Winson had sold to Hin Leong under two different sale contracts. That's labeled as the third leg in the diagram on the screen. So the sale from Winson to Hin Leong. The cargoes in question were in fact really sold by Hin Leong to Unipec. That's the green part of the diagram. Hin Leong had also created a circle for the sale of the same cargo a second time over. That is from Hin Leong to Trafigura, from Traf back to Winson, and Winson back to Hin Leong. And the banks here argued that there was no cargo which was shipped for the Winson Hin Leong sales, and the copy of the non-negotiable BLs, which supposedly showed this shipment, were forgeries. Winson had relied on those copy BLs in preparing payment letters of indemnity, which it presented to the banks for payment. And Winson effectively made two presentations. First, in respect of the cargo carried on Ocean Voyager, it made a presentation to OCBC. And for the second cargo, which was carried on a different vessel, Ocean Taipan, it made a presentation to Standard Chartered Bank. As will become clear later on when we go into the grounds of the decision, Winson later switched these presentations. So it withdrew the presentation to OCBC in respect of the Ocean Voyager cargo and presented the Ocean Taipan cargo to OCBC and the Ocean Voyager cargo to Standard Chartered Bank. The banks in this case essentially argued that no cargoes had been shipped for the sale, and therefore the representations that Winson had made in its payment LOI, suggesting that the cargoes had in fact been shipped by Winson to Hin Leong, were false. And the court found for the banks. In reaching this conclusion, the court examined two main issues. First, whether there were valid BLs for the transactions. And second, whether the cargo described in the LOIs were shipped on board the vessels in question. Baldev, can we go to the next slide, please? As to the preliminarily, before we jump into the factual basis, in this case, the court actually disagreed with the test of fraud which was applied by the SICC in Credit Agricole and PPT, and found that a beneficiary would also be acting fraudulently if he made a false representation recklessly without caring whether it be true or false. So you would recall from Baldev's presentation that the SICC had found that a reckless presentation by itself does not cross the threshold for fraud insofar as presentation under an LC is concerned, but the High Court in this case disagreed with that position. And so as the law currently stands, a reckless presentation without belief in the truth or falsity of the representations which are made would be considered fraudulent. And in assessing whether at the time of presentations, Winson honestly believed in the truth of the representations, it was relevant, the court found, to consider how reasonable or unreasonable such belief would be in the circumstances prevailing. So as we examine the court's decision, you will see that the court actually delved into, the facts at play at the time the presentations were made to assess what Winson's state of mind was and whether that was unreasonable, so unreasonable as to be reckless. Next slide, please, Baldev. Yeah, so on the first issue of whether there were valid BLs, the court found that there were no valid BLs for the shipments in question, allegedly from Winson to Hin Leong. And in this regard, the court noted the findings of Hin Leong's interim judicial managers, who had found the original counterparts of the copy BLs which were used for the sale from Winson to Hin Leong. And these originals were marked null and void and had no endorsements on the reverse side of the BLs. And the IJM had prepared reports highlighting a number of questionable practices, which included that the shipments, there were shipments allegedly made by Hin Leong, where Hin Leong would sell the same cargo to more than one party. The first leg would involve Hin Leong selling the cargo to one counterparty and providing documents such as an invoice, an original BL, and a letter of indemnity. But the second and the third legs were fictitious because they involved Hin Leong selling the same cargo second time over to one or more counterparties with an other BL, which would be prepared by Hin Leong itself and would generally be signed by an employee of Hin Leong, instead of the BL as it should be signed by the vessel owner or the master. And this arrangement, the IJM had also commented, appeared to be created purely for financing purposes. The BLs which were used for the second or third legs, as I mentioned, were typically signed by employees of Hin Leong, and for the cargoes in question, also they were signed by an employee of Hin Leong. And there was also evidence from the liquidators of the owners of one of the vessels, that is Ocean Voyager, that they had not issued the BLs in question, which were allegedly used for the Winson Hin Leong sale. So what Winson really had, therefore, was a copy of a non-negotiable BL, and the banks had disputed the authenticity of these documents. And Winson had led no evidence to prove why these documents were authentic. So the court concluded in the circumstances that the BLs really were forgeries, which were signed by an employee of Hin Leong. And given that the BLs were found to be forgeries, there was no valid BL pursuant to which the cargoes were shipped for the Winson Hin Leong sale, and therefore the court found that the representations to the banks as to the existence of a full set of three original BLs in the LOI were false. The court also found that the cargoes described in the LOIs were not shipped on board the vessels as they had been described in the LOIs. Rather, the court reached the conclusion that the cargoes were in fact sold by Hin Leong to Unipec, which was the green bit of the earlier diagram that we saw. And there was, in another suit where the liquidators of Hin Leong had sued the founder of Hin Leong, Mr. OK Lim had admitted that the cargoes in question were in fact meant for Unipec. Quite apart from this piece of evidence, the court also considered the contrast in the documentation that was available for the Hin Leong Unipec sale on the one hand and for the Winson Hin Leong sale on the other hand. For the Hin Leong Unipec sale, loading documents were available, such as an inspector's report, certificates of quantity, quality, documents one would typically expect would be available for a legitimate shipment, but none of these documents were available when it came to the Winson Hin Leong leg. The court also considered the IJM's position that Unipec was the first buyer of the cargoes, and the court said that it looked like if that position was in fact supported by documents such as original BLs and loading reports for the cargoes. And it was relevant also that at least the Trafigura and Winson sale contracts had in fact expressly required or contemplated an internationally recognized inspector determining quantity and quality of the cargo at the load port. Despite these express stipulations in the contract, no such documents were available. And considering all these factors in the round, the court concluded that the cargoes as described in the LOIs were not shipped on board the vessels, Ocean Voyager and Ocean Taipan. So these were the findings on, just whether the BLs were original and the cargoes were in fact shipped. The court still had to consider a further step, which was Winson fraudulent in making the presentation that it did to the banks in seeking payment. And for that, the court had to look at Winson's state of mind. And here, as I mentioned earlier, the court clarified that the test for fraud would include a reckless indifference by the beneficiary as to the truth or falsity of the statements that it is making to the bank. And on the facts, in assessing whether at the time of the presentations, Winson had honestly believed in the truth of its representations, the court found it relevant to consider the reasonableness of Winson's beliefs. And on this, the court found that there were a number of red flags which would have made Winson's presentation unreasonable to the point of being reckless. And in that regard, I've tried to set out in bullet point form the red flags in question. And some of these red flags included the fact that Winson had never received original BLs nor copies of the reverse sides of the BLs showing any endorsements, proving that the constructive possession of the cargo was in fact passing down the chain. Winson's first presentation under the LC to OCBC was, as I mentioned earlier, for Ocean Voyager, and to Standard Chartered Bank, it was for the Ocean Taipan. Now, OCBC rejected this first presentation on the basis that there was no physical cargo which was shipped on Ocean Voyager. OCBC, and I'm quoting this from the judgment, actually in terms said that there was no physical cargo because they had suspected something was going wrong by that time. And this was a very serious issue for a bank to raise. But the evidence showed that Winson did not even inquire why OCBC was saying so. And that is very suspicious in the circumstances. If the bank is, saying that there's no physical cargo in respect of the presentation you're making, one would expect the trader who's making the presentation to at least do some homework to find out why the bank is making such a serious allegation against it. Instead, what Winson did was it prepared new invoices and LOIs on the very same day as OCBC's rejection to make a second presentation to the banks by switching the vessels. Now, in its second presentation, its second presentation was to OCBC was for Ocean Taipan, and to Standard Chartered Bank was for Ocean Voyager. It would seem to an objective person looking at these, looking at this state of play, that this switch was essentially made by Winson to avoid the issues that OCBC had raised with respect to the Ocean Voyager cargo. And an honest trader in Winson's position would have tried to get to the bottom of why OCBC had taken the position that there was no physical cargo in respect of the Ocean Voyager presentation. Winson had also never received, as we saw earlier, any loading documents such as an independent inspector's report, certificates of quality or quantity, or any equivalent documents. And it was never told that an independent inspector had even been appointed or any inspections had taken place. This also looks a bit suspect for an actual shipment of cargo. And based on previous shipments, evidence was led that Winson should have received loading documentation by the time it made the second presentations to the banks. And in this case, it hadn't received any such documents. The BL quantity, which was shipped on one of the vessels, Ocean Taipan, had also, in this case, been altered after the BL had been issued and the vessel had sailed. And this is not common, despite being another aberration. Winson did not ask for and was not given any explanation for why this was done, why the quantity on the BL was changed. Then there were also discussions between OCBC and Winson, where OCBC asked Winson whether Winson would be willing to repurchase the cargo, and Winson was not willing to do so, although the court said that one would expect a trader who had sold the cargo to also be open to repurchasing it if the price was right. But an unqualified rejection didn't sit too well with that. During these discussions, Winson expressed its willingness to help find a buyer for the cargo, but repeatedly emphasized the need to check if the title to the cargo was clean. And the court reached the conclusion that in the circumstances, what was meant by title being clean was whether Trafigura had passed clean title to Winson, and Winson had in turn passed clean title to Hin Leong. So the court, in the circumstances, reached the conclusion that Winson actually had doubts about title transfer in relation to this cargo. One final point that is not on the list, but was also fed into the matrix that the court considered. After OCBC had rejected the first presentation on the basis that no physical cargo was shipped, all that Winson seemed to have done was conducted some IMB checks on the vessels, all that these IMB checks would have confirmed is that the vessels were not traveling unladen. They wouldn't have addressed OCBC's concern about the cargo not being shipped as it was being described to have been shipped. So it was a very superfluous check which wouldn't have addressed the point which was actually being raised by the bank. So in the round, considering all of these red flags, which, if it's one or two and one turns, one doesn't investigate them, it may not be as stark, but in this case, there were a number of red flags and significant red flags, which were all ignored. And the court said that the court concluded that in the circumstances it showed that Winson was in fact reckless as to whether its presentation to OCBC in relation or to both the banks in relation to the shipments in question was true or false. And The banks had also raised another question about whether the trade contracts in this case were sham, which the court did not have to consider, having reached the conclusion that it did, that there was in fact no shipment, and the presentations were therefore reckless. And this case clarifies that quite apart from the questions of whether the sale contract is a sham, which is what engaged the SICC in the Credit Agricole, the first instance Credit Agricole case, the bank is also able to rely on representations made by a beneficiary to it in a payment LOI concerning the shipment of the cargo in accordance with the BLs in question. And the basic premise of all, of this case is quite simple. If a third party is doing the same trade to the exclusion of the beneficiary at the time of the presentation, then statements made by the beneficiary as to it being involved in the shipment would be false. And if such statements were made by the beneficiary who's turning a blind eye to various red flags and who's recklessly indifferent to the truth or falsity of the statements that he's putting forward to the bank, then the bank would be able to deny payment on the basis of the fraud exception. And this decision is significant in particular for clarifying that, I've belabored this point a lot, for clarifying that recklessness where the representer is indifferent to the truth would be sufficient to establish the mental state for the fraud exception for resisting LC payments in Singapore. And with that, I have come to the end of my presentation 5 minutes before time. If you have any questions, we'll be very happy to take them.
Thank you, Reverend. Thank you. I'll take the slide off. Let's see if we've got any questions. The point about Winson, I think you'll be hard pressed to find a case like Winson never showing up again. It's really quite remarkable, the number of red flags applying at the same time. Put it another way, if I were Winson, today I go to the bank, I say, I've got good title, I've been part of this trade, and then tomorrow when the bank turns around and says, well, we don't think you've got good title, can you find another buyer? And Winston's like, wait a minute, I need to check if I've got good title in the first place. The bank will turn around and say, well, you just told me yesterday you had good title, and now you're saying you need to check whether you've got good title. Which one is it? You should be sure when you're making that presentation. There's some questions over here, just going through them. One question about the timing, in under UCP 600, you need to comply or reject a presentation within 5 days. Yes, I think that I'm not entirely sure. I don't think that happened. If I recall right, I don't think that happened during that time period, and so they've missed that period to reject the documents. The question really is that you've got two sets of learning values, one for the banks, one for the traders. Let's start with the banks first. Let me give you my concluding remarks by saying that it is not the bank's job to go and investigate trade fraud. That's what people like us do, but it's not the bank's job to do it. The bank is dealing in documents. It should be able to rely on the truth of the documents to make documentary credits work the way that it's meant to work. If a bank has to go and unturn every rock to go find out whether a trade is true or not, the wheels of international trade and commerce will come to a grinding halt. That said, whose obligation is it to be sure about the robustness of the trade? Is it the bank who is set one step removed from the transaction, or is it the trader themselves who are involved in the transaction, whether they are originator, whether they are intermediary, whether they're just a conduit? They are part of the transaction and they are better placed to ask the question. So I think the law in these two cases have come to the right result at the end point, being that if you want to pass the risk of fictitious trades, and you will always run the risk of fictitious trades when you're dealing in trade flows where you're not even using the original BLs, then yeah, there's a chance that somebody else is using them for other goods. So that risk, who should it fall on? The bank, whose job is just meant to pay and not investigate, or the trader who's actually involved in the transaction? And I think that balance is pointed more towards the trader, and that is the learning lesson both for the bank and the trader, in the sense that the trader is best placed to ask the right questions and no longer rewarded for closing their eyes to all the red flags. Another question about who to address the LOI to. Should it be addressed to the bank or the LC applicant? Perennial problem. I think this is a good question. yes, it should be when these cases happened in 2020. Zenrock and Hin Leong were not the only cases involving payment LOIs. There were numerous ones we were dealing with as well, and the commonality is that there tends to be a practice of addressing the LOI to the buyer. Naturally, the seller is addressing the LOI to the buyer because it only knows the buyer. It doesn't know the bank and is not interested in addressing things to the bank. So then banks don't have the ability or might not have the ability to rely on the LOI because the LOI was never addressed to them in the first place. So yes, I would say that the best practice obviously is to have the LOI addressed to the bank, not to the LC applicant. But in practice, I know if a big trader tells you address it to me and not to the bank, I'm not sure how much leeway a seller has with that. So there's always difficulty in that sort of cases. Let's see if we got any more questions. One last question because I know we've just reached out of time. Switching invoice and the vessel under the same LC after the first presentation being declined, wouldn't it be a blatant red flag? This point I think has to deal with the Winson oil case, and that is absolutely right. If you present to the bank and say, here you go, the bank says, I don't think what you said is correct. In other words, the bank is saying, I think you're being fraudulent. And then you say, well, let's just switch it with another set of docs. Here you go. That to me looks quite bad. If you ask me what really swayed it with Winson oil, I think it's some of that behavior, that switching of the BLs, of the cargoes, and some of the behavior post-presentation in terms of being so worried about whether they actually had title. I think that left a remarkably bad aftertaste to anyone reading the case, to think, it's quite hard to have any sympathy with Winson in a case like that. Unfortunately, we've got 1 minute past. I'm happy to take any questions. Please feel free to email. I'll answer some of your questions by email. We are recording this and we'll share it in due course as well. I'd like to thank everyone for their presentation today, for their involvement today, and to my colleague Raman for her presentation. Thank you, everyone, and have a good day.
Thank you, everyone.